Good morning, this is your Kelso Report for Friday, June 8th, and I'm your host, Clark Kelso. We began with the Ninth Circuit case involving habeas corpus and limitation of action, statute of limitation. The issue before the Ninth Circuit in Thompson v. Leah was whether a California Supreme Court grant and hold in a criminal case, followed by an order ultimately dismissing the appeal, should be treated for purposes of federal habeas as restarting the one-year limitations period in which a state prisoner must file a federal habeas corpus petition. Now, this case is procedurally unusual and is not likely to arise very often. The petitioner's conviction initially became final on July 11, 2006, 90 days after the California Supreme Court denied his petition for review on direct appeal, without prejudice to any relief to which defendant might be entitled after the United States Supreme Court determines in Cunningham v. California the effect of Blakely v. Washington and United States v. Booker on California law. In other words, it seemed to be a denial that was contingent upon future action by the Supreme Court. Well, after the Supreme Court decided Cunningham, the defendant filed a motion in the California Court of Appeal to recall the remediature and reinstate his appeal based on Cunningham. The Court of Appeal denied the motion, but the California Supreme Court granted review of the petition for review of the Court of Appeal's denial order and deferred further action in the matter pending decision in a different lead case. This is known as a grant and hold, and in this particular case there were about 125 cases who were potentially affected. When the lead case was decided against the defendant's position, well, the court then dismissed the appeal. The Ninth Circuit majority held, correctly in my view, that by granting the review and hold, the California Supreme Court reopened direct review and made the defendant's conviction again capable of modification through direct appeal, which is the federal standard. The fact that the California Supreme Court ultimately dismissed because of the resolution of another lead case does not change the fact that the grant and hold revived the state appeal, and the revival should have restarted the one-year limitation period for federal habeas. Next, we turn to the Supreme Court of California, which had a case involving the definition of burglary. The defendant in Magnus v. Superior Court was charged with burglary because he used a remote control to open a motorized garage door. The California Supreme Court held that no burglary had been committed on these facts. Now, as I'm sure we all remember from law school in California, a person who, quote, enters any house with intent to commit larceny or any felony is guilty of burglary, close quote. And it has long been settled that the slightest entry by any part of the body or any instrument is sufficient. But in this case, no part of the body and no physical instrument entered the house. At most, electromagnetic waves from the remote entered the house. But that was not good enough for the Supreme Court, which looked for something physical to go from outside to the inside of the house. So as a result, the defendant can be charged at most with an attempted burglary, not a completed burglary. Next, from the California Supreme Court, a death penalty decision. In People v. Streeter, a jury had convicted the defendant of first-degree murder and found true special circumstance allegations of lying in wait and intentional infliction of torture. The trial court declared a mistrial as to the penalty phase after the jury could not reach a verdict. And at the beginning of the penalty phase retrial, the trial court released the jury after granting defendant's motion for a continuance. At the second penalty retrial, the jury returned a verdict of death, and the trial court then imposed that sentence. It took the California Supreme Court unanimously 82 pages to affirm the judgment. Next, California Court of Appeal, an attorney's fees issue. In the published portion of its opinion in Cullen v. Corwin, the 3rd District enforced a contract provision in a standard form real estate purchase agreement that denied attorney's fees that would otherwise have gone to the prevailing party if that party sued before seeking mediation or after suit was filed, refused a request to mediate the dispute. The buyers of a home in this case had sued the sellers over an alleged failure to disclose defects in the garage, and the plaintiffs then requested mediation, which defense counsel rejected. Plaintiffs ultimately lost the case, and the defendant sought attorney's fees pursuant to the contract. Defense counsel argued that the plaintiffs' failure to provide responses to various discovery requests justified their refusal to mediate. But there was nothing in the contract provision at all suggesting that its terms could be excused or justified, so the 3rd District held the defendant was not entitled to attorney fees consistent with the terms of the attorney fee clause in the contract. And that's it for today's Kelso Report. Have a great day in the law.